lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O and Rene with today's expert in their field.
How about just half of Steve-O and Rene? Rene is still very much part of this team, but we have a morning show that we do every morning from 7 to 10, and someone's got to write the show. So I'm writing the show, and I'm doing this show, and Rene's just sitting back doing nothing. Boy, she's going to kill me when I get home. Anyhow, good afternoon, and welcome to another Ask the Experts, where we bring in the top law firms, doctors, and home improvement companies. And we have this first Monday of the month. We're starting to get a lot more calls, which we appreciate. I already even got an email, 2 of them already, before the show. Let's welcome from Kaye Bender Rembaum, Robert Kaye and Michael Bender. Hi, guys.
Good afternoon.
Now, see, this way I always know the first Monday of the month when you guys show up. They kill me, though. Our show starts at 4, and they get here about 20 seconds before 4. I'm always wondering if you're going to make it. You do this to me on purpose.
Always do, though.
You do.
We always make
95 is always an adventure.
It is. Listen, I take that every morning, and we're in Coral Springs. So we're going to talk about your firm first. And I can say this. I don't think you guys are allowed to say this, but this is the top firm in Florida. I used to say just South Florida, but you're all over Florida when it comes to condo associations, HMOs.
No,
I say HMO.
HOAs.
God, I did a medical show this morning, HMO. But
Community Association.
You guys lead in Florida. You can't say that, but I can. You've got like over 800 clients.
Communities, yeah.
Please don't change that because, don't make it 900 or 1,000 because I know it by 800. But anyway, let's welcome you guys. And, man, we love having you on the show.
Thank you.
It goes by so fast. Even the hour goes by fast. So we got to talk about your firm first and what you do. Who's going to go?
I'll be happy to. How you doing, Steve? As you mentioned, Kaye Bender Rembaum, we are leader in the Community Association representation. And what that basically means is, as you said, over 800 of our clients, which are community associations, we act as general corporate counsel for these clients, boards of directors, these great volunteers throughout the state who step up in many times a thankless job. This is where they live, it's their homes, it's their communities, but they also are running businesses, and some of these are very large businesses. So in that setting, it is a corporation they're running, and we come in as corporate counsel, general corporate counsel, with the corporate entity, in this case being the association, and we help them, basically soup to nuts. We help them on day-to-day issues when it comes to operations, procedures, when it comes to reviewing their every community has a set of governing documents, declaration, articles of incorporation, bylaws, and rules, and we assist with interpreting those, amending them, reviewing contracts, covenant enforcement, construction defect issues, really anything that comes up.
It's amazing how much there is to know.
It really is. And
it's
every
like
day
running a major
changes.
corporation.
Well, it's also like running a municipality. In Florida, it's not like what we know from up north where cities do a lot of things. Down here, the associations stand in for the cities in many instances.
That is true.
And a firm like yours, this is the best route to go because you really don't want to do this yourself on your own.
This is a matter of want.
It's a matter of you shouldn't. Again, you're volunteering as a board member. And years ago, I served on the board of my community. So
you did?
I certainly did.
And he said so happily.
Did you charge him?
I was a board member. We weren't. It was a volunteer position, as everybody knows. But in our role as board members, everyone who lives in a community should know that they have rules and regulations, restrictions. They have a responsibility within the community. But when you decide to step up and be a board member, your responsibility is now enhanced that much more because really you're taking on a role where you have a fiduciary duty to the membership as a whole, where sometimes a decision that might be best for you isn't best for the community at large, and you really should be able to separate those things. But in your capacity in that role, you want to be able to reach out to experts in the field to assist you. Many communities, especially larger ones, have managed either on-site management or management teams, and there's some great management companies in South Florida that these boards should be looking toward to help them with business guidance. A great insurance agent, an insurance company, CPA. These are things that you utilize in running these corporations, and you should have a budget in your line item for legal. I still on occasion run across. I was recently at a couple of expos, and it still surprises me a little bit to find that there are board members coming up and saying, "Oh, we don't have an attorney." I said, well, that's concerning, because there's no question there are issues that have come up, legal issues, where they perhaps escaped, fortunately, or it hasn't bitten them yet, or perhaps they're just things are falling through the cracks that they're unaware of. So it is important when you have your fiduciary duty to your membership. I think behooves you to have experts in place, and one of those should certainly be corporate counsel.
First, let's give everybody your website. You've got a tremendous website.
The website's kbrlegal.com.
Thank you.
And you can actually watch the show right now live, or you can go back and watch past shows. There's so much great information on there. We got a letter, an email the other day. I guess there's a lot of people who've never been involved with an association.
Well, there are a great many people who have not, but it's a dwindling number in Florida, as most communities do have some form of mandatory association.
Well, I got a letter. It said, "Why did I get in trouble for painting my door that didn't match everyone else's door?" So I don't think that he's never probably
because he wasn't familiar with the covenants that that bind his property. Whenever you buy a real estate property, a residential property in Florida, you should receive from the sellers or the title company handling it a complete set of the documents that affect your property. And within those would be the restrictions such as needing association approval to make an exterior modification, such as changing the color of your door. There's a procedure that's typically in place with an application that goes to the association representatives, either through management or directly to the board of directors. A review process, there's usually specifications in place of what colors are allowed, what colors are not, and things of that nature, which should be reviewed before you go and paint your house, not after.
Why would an association not, I think there must be, because we got an email, not allowed to fly an American flag?
Well, that is something that is an improper action by the association.
Oh, interesting.
The statutes in place for condominiums and homeowners association have been amended through the years to require associations to allow the flying of an American flag in an appropriate manner. Now, if the person's not flying it in a respectful or appropriate manner, then there may be an issue. The association is allowed to create certain rules regarding how it can be displayed, the height of the flagpole, or things of that nature, but you cannot prohibit it.
So what should this person do if they asked him, and the person, something, doesn't matter who it was, asked him to remove the flag?
That person may need to get some legal assistance if that person's not familiar with the statutes, and the association may not respond the same way to him telling them what the law is. It may take an attorney to assist.
Okay, if I want to give out the phone number here, it's 888-565-1470. If you have a question for Robert or Michael, we'd love for you to call right now. We've been really getting some really good calls. Let's talk about, you have a lot of seminars coming up.
We always do.
And I want to mention free seminars.
They are, yes.
Where should we start?
Well, where I'll start actually is this is our first full year doing the radio show, and so I guess we did it the same time last year. But one thing Robert and I have done with Kaye Rembaum for this will be our 8th year doing it. It's an annual town hall series, it's kicking off next month. That kicks off December 9th. The first town hall session will be 10 a.m. on Wednesday, December 9th at the E. Pat Larkins Community Center in Pompano Beach. It is, and again, going to our website at kbrlegal.com, you'll be able to get all information on that. But we're very excited. We've always been excited about this series. We're well attended, and it's really great give and take. And the reason for that is because we've developed this program where it's essentially come out, ask the attorney. Come ask the questions that you've been wanting to ask, haven't had an opportunity to. Either you don't have an attorney, or you're not comfortable with the attorney you have, or the information you've been getting from that attorney you're not buying into. But it's an opportunity to ask questions of experienced community association counsel, which at this point will be Robert and I for the most part. We've done it for the last 7 years, so I think we'll continue to do it ourselves because we do enjoy it.
Tell everybody about this.
Yeah.
I was actually at one of your
Right.
towns.
Yes, you
They were
were.
amazing. There was a lot of
That's
great
right.
questions.
And it works that way. What we do is we ask everyone to RSVP to KBR Legal Seminar at pearsongrant.com, PIERSONGRANT.com, or call 954-776-1999 and RSVP. But what we want with the RSVPs is we want you to let us know who's coming, how many, bring a crowd, but also what topics do you want to discuss, or what questions do you want to have answered? Because when we sit down, when Robert and I start this session, we usually have a list of 15 to 20 questions or topics from those who are in attendance. And this way, the subject matter that we do at these programs is geared and germane to those who are sitting there at the session. And this way, no two town hall seminars are necessarily the same, because it's going to really be dictated by the attendees, not by us.
And those questions always lead
And
to
they lead to
additional
more questions, and it's great. And the people and a lot of people have told me, I didn't have any particular questions, but I came and it was great because all of these fellow community association leaders, fellow board members and managers come up with questions that they've been struggling with, and someone who might not have otherwise thought of it said, oh yeah, that's an issue that we're going to be facing soon, and they get some guidance on how to address it. So we're excited about it.
We heard a lot of good comments last time, too. People really enjoyed the seminar. So it's December the 9th.
Wednesday, December 9th at 10 a.m. This first session is going to be a morning session, and that's at the E. Pat Larkins Community Center in Pompano Beach. And then we will be offering additional programs in the seminar series, at least two in January, 2 in February, 2 in March. The entire schedule will be released sometime in the next few weeks. It might some of the other dates may already be posted at kbrlegal.com. But we're very, very excited about the town hall.
You can also get the RSVP information on the website as well.
And we're going to repeat this in the second half of the show. We had an email that asked about the election process in condominiums.
Well, the election process was adopted by statute in the middle of 1991 for 1992 kickoff, and provides for what seemed to be a complicated but has been a very effective method through the years. The first requirement is that the association mail a 60-day notice to all of its owners, not less than 60 days before the election, with the date that the election is going to be, and an invitation for any interested owner to submit themselves to be a candidate to run for the board. That's the only way to have nominations in condominiums, is submitting a written request to be a candidate to the association not less than 40 days before the annual election.
That's hard and fast.
That's hard and fast, and it's even if it's a holiday, it doesn't roll down to 39 days. It rolls up to 41 or 42. So it's critical on the timing, and on the date that is due, the individual has to be qualified to serve on the board, meaning they can't be more than 90 days delinquent in assessments. They can't be a convicted felon who has not had their civil rights restored for more than 5 years, or previously suspended from a board by the Division of Condominiums. So, primarily where we see issues of qualification is on the assessments.
Is it different? Homeowners different than?
Homeowners is different.
Okay.
Homeowners will depend on what your documents provide, but the condominium election process is strictly statutory. Okay. So the owners who are willing to run for the board also have the option of submitting an information sheet about themselves, and they have until 35 days before the election to do that. One single sheet of paper, 8.5 by 11. And then the association is required to send a second notice out to its membership, not less than 14 days before the meeting, but obviously more than that is better, but obviously not less than 34 days, because owners have the option of submitting by that 35th day. With that second notice will be the ballots, the envelopes for the submission of the ballots to the association, which includes an inner envelope that's blank to hold the ballot to keep it secret, which goes into an outer envelope that the owner fills in their unit information to identify who's voting. And that has to be submitted back to the association either by mail or hand delivery up to the date of the annual election.
We got to go to break. We're running a little bit late. When we come back, we had an email that someone wanted to know if they have a firm that represents them, can they come to your firm for a second opinion?
Well, let's talk about that when we come back.
We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. The phones are already starting to ring already. Let's go to the phone first, and we'll come back. I've got some questions for you. We have on the line Giselle.
Hi.
Hi, Giselle.
Yeah, hi, how are you?
Oh, that's much better.
We couldn't hear you, but now we can.
Oh, okay.
Where are you calling from?
Great. Hello?
Where are you calling from?
Oh, I'm calling from Boca.
Okay. Right in the neighborhood.
Yeah, it's wonderful. I love it up here. I'm from New York, so I'm enjoying the weather. I just have a quick question. Our Homeowners Association new president believes that since our HOA documents follow Robert's rules, meaning our monthly board meeting minutes should only contain our meeting's location, our start and stop times, attendance, and motions, should more details be included in this information?
From a legal standpoint, what you've just described, and I guess what your president has described, is accurate. The minutes are not meant to be a transcript of the meeting. The minutes are meant to contain the information that you just provided. Whether any more detail than that is provided, it would be ultimately up to the board to decide with the secretary or whomever is the minute taker. But our suggestion, our recommendation is that the minutes should be as you described, which is really notify. It should confirm who's in attendance, quorum's established, and then actions that any motions that have been taken, and actions that have taken on each of those motions. And if there's discussion, it's okay to say that discussion ensued, as a general statement. You don't need to be more specific, and certainly shouldn't act like a transcript.
And Giselle, it's important that it not in many instances, because if you put too much information into the minutes, and down the road there's some kind of litigation that involves the association, while this information isn't actually actions taken by the board or binding on the association, it has been known to come back and work against the association for whatever reason in the litigation process. So it's always best to keep it as close to the bare minimum of what's required under the law. We actually have an interesting article on the topic on our website in the legal morsel section at kbrlegal.com. Just click on the legal morsel tab and look down the topics to get to minute preparation, and there's a nice article there that might fill in some blanks for you.
Oh, okay. Thank you so much. You've been such a great help.
Hey, thanks for calling.
Thanks for listening. So,
bye-bye.
It's the more I listen to you, there's so much out there that people need to know. So these courses you offer are so important. And do you have any courses that are coming up in November?
We do. But this course is every month, and we have, as you know, we have two offices. We have our Palm Beach Gardens office, which is 9121 North Military Trail, and our Pompano Beach office, which is 95 in Copans, right off of Andrews there. And in November, we will be offering condominium board certification classes in both locations. On November 10th in Pompano Beach and on November 18th in Palm Beach Gardens. They are in the evening, 6 or 6:30, depending on which location. Also in November, both locations will be offering fair housing courses. It's a Fair Housing Act. It's a 1-hour program, assistance animal versus pet, which remains a very hot topic. In fact, I was just did 2 expos this past month in October, and then did the fair housing class at both, and they continue to be very well attended and continue to have a lot of people frustrated by that. But November 19th and November 25th. November 19th at Pompano Beach, November 25th in Palm Beach Gardens. So I would encourage everyone to look at our website, kbrlegal.com. Also, Rembaum's Roundup, which is a publication of the firm that is Jeffrey Rembaum manages, also does contain all the seminar dates. And if you're interested in getting on the mailing list for that, you can send us an email at info@kbrlegal.com. But as Robert Reese just mentioned also, in addition, on our website, in addition to the seminar series, there is a lot of free education. The legal morsel sections and the Rembaum Roundup sections are both 2 excellent sources of articles written by us, by experienced community association lawyers, on relevant, pertinent, and topical community association issues. Obviously, it's all free to access, and we encourage any community association leader or manager to take some time at kbrlegal.com and click on those tabs and review those articles. And any publications out there who are looking for articles for the publications that are valid and articles that will support community association publications, we're happy to have those articles republished so that more education can be shared.
And as long as we're talking about the website, it's important to also point out that for our clients, we also have the ability to access collection matters we're working on for their associations for delinquent assessments 24/7 with up-to-the-minute information of what's going on in that particular file.
They can access it off your website.
Off our website, yeah.
Wow.
Yeah, that's a real nice tool. A lot of our clients are very happy because in the past it's been a monthly report that you'd wait to get mailed to you or have to reach out for, but now...
And it's usually behind the time.
Right. Now with automatic, I tell them, you have a meeting, no matter when you have your meeting or whatever questions you have, you can go right to the website and you have access to all the information we have.
Give us your phone number again and your website address.
The phone number is 800-974... That's just a block, 0680. That'll reach either office, 1-800-974-0680. 800-974-0680.
Website address again.
Is kbrlegal.com.
Okay. So you do the certification courses.
We do.
Who should attend those?
Anyone who's interested in being in any sort of leadership position within their community. Committee members, board members, managers. We offer CEU credits for attending those classes. So bring your boards, get them certified, get additional education for yourselves. Really, if you're going to serve on your board now, if you're serving on your board now or ever think you want to serve on your board, get the education. As far as the certification requirement, the state does require all board members, HOA, condominium, and cooperative board members, to have certification. One way to get that certification is to go to a division-approved education course. We happen to be a division-approved provider. And what's great about the certification for the course is you take the course today, and that certificate is good for a year. So if your election, say, is in January or March of next year, or now we're into November, so if it's October of next year, and you came to our course in November, and got your certification for, if you're a condominium board member, if you run for your election between now and next October, you can provide that certificate if you get elected and you have met your certification requirement.
This is really important.
It's very important. The certification is when you step. I mean, we've talked already a little bit about the fact that you are volunteering to run a business, and even business owners who run their own very successful businesses. A lot of that, of course, can carry over, but there are a lot of nuances to running an association, and especially because there's a lot of statutory procedural issues in place, and to come and get educated. And the education class, by the way, is not only, it's on operations, it's on budgets, it's on finances, it's on record keeping, it's on covenant enforcement, it's on so many aspects of what you need to know. It's 2.5 hours of just excellent education, and you take reading materials home with you, and snacks are free.
Property managers can attend?
Property managers should attend as well, because not only do they get the great education, but we do give them free continuing education credits toward their license requirements.
Now, from being on the show, you guys, there's a lot of people who listen, a lot of people in management out there. I told you we got an email from someone, I guess, has a firm that represents him, but he wants a second opinion. Can they still come to you?
Well, absolutely. There is no limitation on the number of attorneys that any individual, corporation, entity may have working for them. So, yes, we would welcome the opportunity for somebody to meet with us and get a second opinion. We offer free consultations in many, many instances. So, one shouldn't be shy about contacting us to see if we can see them if it's in their budget. Also, I do want to point out, not on the same topic, but on the November 25th seminar in West Palm Beach, or the Palm Beach Gardens office, that has actually been canceled, so there is none that night in Palm Beach Gardens.
God, you pointed that out.
Well, it is the night before Thanksgiving.
Oh, okay.
Oh, that's right. Thanksgiving.
Can I have your pen?
You may.
See, I'm going
'Cause we're gonna
to
be
cross it off on mine.
We're going to be announcing this
I
again in
didn't
the
want to
second half of the
forget,
show.
since I did have that information available.
Thank you. I was on a need-to-know basis.
I just got it.
We're gonna go to break. I want to give out the phone number when we come back from break. If you've got a question for either Robert or Michael, call us now at 888-565-1470. Maybe you're having a problem with your association and you need answers. We've got two of the best here, so give us a call, 888-565-1470, and we will be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. It's a beautiful day out. I'm just looking out the window right now. We are here with, this is, I'd say, and when Renee's here, we both say that Kaye Bender Rembaum. Write that name down. Kaye, and it's Kaye, Bender Rembaum. They do association law. And they must be doing something right. They have over 800 clients. They've been with us well over a year. I have learned so much about association law. And what I love about what you guys do, you give back so much. I mean, everything you do, this is free, this is free, this is free.
With a light snack.
Yeah, with a light snack. But because when I come to your office, you guys are so busy, but you take the time out every month and you do these seminars. And it's rarely do you hear that in the industry anymore. So hats off to you guys for that.
Thank you.
We always have new people tuning in. Tell everybody just a little bit about your firm.
You want to go this time?
Sure. Kaye Bender Rembaum has been continuously providing community association representation in this area since 1992 and has been working with many community associations of condominium, homeowners, cooperatives, and even those that are in the mobile home parks on some occasion. We provide the full range of services that are necessary for operations of a community association, handling covenant reviews and opinions as to what your documents provide, assisting in contract negotiations, dealing with enforcing construction defects, complex litigation if it should arise, more simple litigation of covenant enforcement nature if somebody's violating the provisions of the documents, assistance in all facets of statutory analysis and review as it affects decisions that the board is needing to make. We do so in a way that is also geared toward customer service. We return all of our calls that come in on the day we receive them. If we can't take them upon receipt, we respond to questions in writing in a way that is understandable to the layperson so that you don't have to hire a lawyer to translate what you got from your lawyer. You can understand it and you can use it, and it's customer friendly. You don't call your lawyer just because you're pals and you want to chat. You have an issue that needs to be addressed, and you need it addressed quickly, efficiently, cost effectively, and you want to be able to understand the information you receive.
Let's,
And that's what we offer.
okay,
That's how we roll.
well, it's amazing how much it's getting hip on us, right?
Yeah.
You guys wear the best looking ties too. Yeah, Kaye Rembaum is.
Don't forget Bender.
Kaye, well, because your tie is amazing.
It's a clip-on.
Your kids listening now?
No,
They're not.
probably not.
Okay.
They've got homework.
Oh, that's right. So
They listen the first 6 or 7 months, but the novelty for them is one of them.
I know.
But others out there need to be getting the education. They need to be doing their own education.
Let's go over all the seminars you have coming up.
Oh, there's too many.
And we know now that there's one that's not going to be coming up.
Correct. Was one less, you're right. Well, let me start by reminding everyone, kbrlegal.com has a list of all the seminars. And I encourage everyone to utilize the website. We've recently, as you know, in the last couple of months, we redid the website, made it more user-friendly. As Robert mentioned, all of our clients access that website every day with collection-related matters. They have access 24/7 to it. There's sections on the website that give free education under Legal Morsels and Rembaum's Roundup. And then there's a tab on there for seminars, and you can click on that and get more information. In November, we'll be doing the Condominium Association Board Member Certification in Pompano Beach on November 10th and Palm Beach Gardens on November 18th. We'll be doing the Fair Housing Act seminar. That's the 1-hour class, Assistance Animal versus Pet, and that's on Thursday, November 19th. There are also classes coming up in December, which we can, December 2nd.
That's important to talk about now because we may not be here before
There's a
that.
class on covenant enforcement and elections in Palm Beach Gardens set for December 2nd. I'll take that. I want to talk to you about this.
Okay.
But then also we have the town hall seminars, which start, and I want to let everybody know now because the first one will be December 9th. So I believe that's probably the Wednesday after. We'll be back here that Monday, the 7th. On that Wednesday, December 9th at 10 a.m. will be the first in our 8th annual town hall series. The first of 7 or 8 programs we'll be doing. This one's in Pompano Beach at the Pat Larkins Community Center. It's scheduled to run 10 to noon. We'll see.
And
Usually,
they can send their questions in prior to.
We encourage that, yes.
They should check out the website for the RSVP information. We do ask for RSVPs because we need to know how many are there so we can have enough snacks. We need also, more importantly, for people to submit their subject matters and their questions so we can have a great program. And we're excited about it. So there's a lot of great stuff going on.
Again, if you have a question, you can call us right now at 888-565-1470. There's no way you guys can leave here without talking about pet issues.
Oh, of course there is.
Got to talk about pet issues.
I told you I just did a couple of classes on fair housing, and
I mean, it's still a hot topic, right?
It does. It remains. It remains a hot topic, but I think it's unfortunately it's one of the more frustrating topics that everybody runs into.
At least from the association
From the
perspective.
association perspective, for sure. But we do offer a 1-hour program on dealing with assistance animals, and because there's a lot of communities that are either no pet or pet restricted, and what board members and managers need to understand is if someone has an assistance animal, which is more commonly known as the emotional support or companion animal, they are not under the eyes of the law. They're under the Fair Housing Act. Those four-legged animals, and we'll consider them, let's say they're dogs, are not considered pets. They look exactly like the pet, but they're not considered pets under the law, and as a result, you can't treat them as a pet, and as a violation of your restrictions, you have to give what's called a reasonable accommodation to that no pet rule or no pet restriction, and allow the animal in under specific instances. And what's becoming a lot more frustrating to many in the association world, if you will, is what appears to be a significant amount of abuse of this particular law. While there are very, very many people out there who truly have a need for an accommodation and perhaps an assistance type animal, there has been an overwhelming increase in the number of individuals in no pet buildings who suddenly need one or more assistance
Well,
animals.
tell everybody the difference between assistance and a service animal.
Well, briefly, because truly it's a whole course that we put together, but I will tell you that the service animal is what you're talking about under the American with Disabilities Act. The American with Disabilities Act governs places of public accommodation. So when you're out in the general public, a service animal is what you would see, and a service animal has requirements. It has to have certification, it has to have training, and currently under the ADA, the American with Disabilities Act, it's either going to be a dog or a miniature horse. Those are the only two. Under fair housing, which is what we're talking about, those are residential communities, which for the most part are the community associations we deal with, the HOAs, the condominiums, the cooperatives. The Fair Housing Act applies, not the ADA. So you don't have the service animal, you have what's called the assistance animal or support animal. And they do not need any special certification. They do not need any special training. The fact that someone comes to you, prints out a certificate from the web and says, look, my dog is certified, does not matter. It's not giving them any more. It's not good or bad. It doesn't offer anything more to that individual making that request, because there is no certification or training necessary. And I think most people can go to these websites for $29.95 and get a certificate.
Wow. And a vest.
Right. But but with the assistance animal under fair housing, as I said, no certification, no training.
So how are people abusing it?
And well,
They're getting medical letters.
Letters from a qualified medical provider has been expanded. It's not just necessarily a physician, although physicians, we have seen what appear to be form letters from physicians. We have scenarios where individuals can go on the internet, communicate with a doctor in another state across the country, and somehow that doctor can now diagnose them and prescribe for them, and so they come in with this letter. But letters can be from other than medical. It can be from psychiatrists, psychologists, qualified social workers, and so it appears to us that as the HUD, who is the federal agency who governs this, as they come out with more regulations periodically and regulations addressing this issue, that it seems to water down more and more to the extent where a letter from just about anybody. My brother-in-law said, I need this
handicap
animal.
parking stickers.
Right.
The courts do not necessarily see things as liberally as HUD does, but you have to
Correct.
go through HUD first, and it's very expensive to deal with through the court system.
That is a very good point. And that's where there's very little case law on the subject that is supportive, because, as Robert pointed out, it's not necessarily an inexpensive proposition, and there is the risk there. And so there have been a few communities who, because it's federal law, so it's across the state, across the country, that have pushed this issue, and we've gotten some good case law which supports the ability of associations and board members to actually undertake a reasonable investigation and not just take someone at their word that, hey, here's a letter, I'm entitled to it. But it's such an important issue to get with your counsel. Get with experienced association counsel when dealing with these assistance animal issues, and don't ever just say no. Don't just say no. Say yes. Don't
That's
say
the
yes.
most important thing you can say.
Don't just say no, but don't just say yes either. Do your due diligence.
Okay. Well, we got a lot of calls here. Let's go to Fernando first. Hi, Fernando.
Hi, how are you?
Good. How you doing?
Good, thank you.
Where are you calling from?
Calling from Miami.
Miami. Okay. What's your question?
My question is, I don't feel that our association amends our documents properly. So what is the best procedure we can follow to ensure that they're amended properly? And what happens if they are not amended properly?
Well, in order to amend your documents, you have to follow the procedures that are in your documents themselves as it relates to the number of co-owners, if necessary, to approve the proposed amendment that you're considering. It's very important, if you're considering amending your documents, that you do have legal counsel assisting the association so that the language that is put into the amended documents is appropriate. You know, we don't necessarily like to see legalese, but when you're putting restrictions on real property and recording it in the public record, you know, these are very serious issues, and you want to be able to be sure you do not have ambiguous provisions that could be interpreted in multiple ways. So it's important to be precise on what's being done. Each of the documents of a community, the Declaration of Condominium or Covenants, the Articles of Incorporation, and the bylaws, each have their own provision that identifies the amendment process that you follow with respect to how many of the owners are needed to approve the amendment process. Sometimes we'll see documents that can be amended by the board alone, but more often than not, this might be the bylaws as opposed to the covenants, which are affecting the real property. So the best approach is to follow what's required by statute in condominiums, and that is prepare the adjusted language with the proposed amendment first, have the board review it and approve it, and then send it out to all of the owners with either a proxy for a specific meeting date, if your documents allow in a condominium or in a homeowner association, you have a statutory ability to go by a written consent without having a meeting, where you can fill out an agreement and send it back to the board that you consent to the proposal. Meetings are good to talk about the issues depending on how many proposals are being made for changes. If it's a couple of items or if it's a complete rewrite, you want to be able to communicate to the owners what changes are being made. And then you have your meeting or your deadlines for the approval process. Once you have the necessary number of owners that have approved, the changes need to be recorded in the public records of the county that the property is located in. The added requirement in homeowners association is they have to send out notice to all the owners after it's been recorded of the newly amended provisions.
Does that answer your question?
Yes, perfect. Thank you very much.
Okay.
Well, thanks for calling, Fernando, and good luck on the amendments.
Okay, thank you. Have a good afternoon.
I think our next caller is Jay.
Do we have time or a break?
Good afternoon. Quick question. If a board of directors refuses to comply with some basic statutes, where can owners go to submit a complaint against the board of directors and the property management company that supports whatever the board tells them to do?
Well, that's going to depend for you, Jay. Are you a condominium or a homeowner association?
Well, we have both. We have a homeowners association and we're a condo. We have a master homeowners association and then an individual condo.
Well, with the condominium association, there is this DBPR, Department of Business and Professional Regulations, does have an investigation division where you can reach out to them and make inquiry with what you believe the actions being taken or not taken are improper, and they'll undertake an investigation.
But they have limitations as to the topics that they can review.
Correct.
Well, a general question such as getting copies of meeting minutes or getting copies of bids for a fence that they're putting in around the pool.
Well, access to official records. Access to official records is a is an area within the scope of the authority of the Division of Condominiums for the condominium side. There is no agency for homeowner association, so you would need to basically file an action in the circuit court or the county court, depending on the situation, to get the relief
To demand turnover. Now, have you asked for the records in writing?
Well, I've asked, for example, if I can't attend a board meeting and I want copies of meeting minutes, I must send a certified return receipt request, and then I must pay 50 cents a copy. They will not accept an email request. They will not accept the hand-delivered request. They will not accept the fax.
Well, for condominiums, they don't have the ability to limit you in that fashion. Any written request is something, as long as you can demonstrate it was received.
Unless they've adopted specific rules that require certified mail.
Well, they're quoting the Florida statute. They're quoting the Florida statute that says that it's got to be done certified return receipt. Even though that's 2013, they refused to adhere to the 2014 or 15 statute that says electronic request is acceptable.
Well, with regard to official record requests, a written request is required, and it's if the board has adopted reasonable rules and regulations, which would include that in order for a request to be honored, it's by certified mail. The division who oversees this has stated that is a reasonable rule, and in order for them to have to comply, you would have to comply with the certified mail request. So, in other words, I will tell you that there are many communities who sometimes will be happy to provide board minutes, but if they're sticking by this requirement, then if you're not able to then each month you send that request certified mail and pay the $2 for the 4 pages.
But you're also not supposed to be asking them to send you copies of things. Your request is supposed to be for you to come in and have access to the records and identify the records that you want copies made of and obtain the copies in that fashion.
Right.
If you send them a letter that says, send me any document, they can properly refuse you.
Okay.
And by the way, if you do go in, you are able to bring a portable device, so you can take your phone, for example, and snap pictures of minutes.
Understood. Yeah, the concern is that to submit the request, they're saying that Florida statute requires a certified letter.
Well, Florida statutes do not specifically require a certified letter, but Florida statutes and the Florida Administrative Code. You're in a condominium?
He says both.
Yeah.
All right. But correct. I'm sorry. Yes. The condominium portion, the Florida Administrative Code, which governs condominiums and cooperatives, does provide that the board can adopt reasonable rules and regulations, and I suppose they could for HOAs as well.
Well, there is a provision in the homeowner statute that says that if it's not submitted by certified mail, there's no presumption of willful withholding if it goes beyond 10 business days. It doesn't mean it has to be by certified mail, but it's recommended that you can deal with that issue.
And that's probably what they're looking at in the HOA Act. There is no similar... there's no similar provision in the Condominium Act, but like I said, if they've adopted a rule, the Administrative Code specifically says they can adopt that as a rule.
They can adopt it. Okay, so if I follow their rule and I send them a certified return request receipt, they do have to provide legal unit owner names and legal mailing addresses if a number of us want to reach out and try to vote the board out. They do have to provide that.
The roster is part of the official records, and as Robert mentioned, they don't have to provide anything specifically to you. They have to provide you access to the official records.
So they're going to make you come in.
Right.
So your request would be to inspect the records, and you can say, "I'd like to come in and inspect the records," or you could provide me this, one way or the other. And then, but the unit roster would have the unit owner's names, mailing address, if different from the unit address, and that would be pretty much the only things required.
Okay, we're finding a board that obviously is very closed, but I do appreciate your information. Thanks,
Ray. Hey, let's go to break. We'll be right back.
Could your community association benefit from having a more hands-on, education-centered insurance agent? For over 30 years, SCAR Insurance Group has worked with hundreds of community associations throughout Florida, putting education first. Let's face it, insurance can be very complicated and complex. It really pays for itself to partner with the right insurance agency and not just get a quote. Family owned and operated, every employee at Scar Insurance takes pride in creating an exceptional, warm, family-like experience for every client, every time. Scar Insurance Group specializes in community association insurance, but can also assist you with home, auto, business, and life insurance. Aren't you tired of not getting all the facts up front from your insurance agent? Contact us today for a free, no-obligation analysis of your current insurance program. Call now at 800-299-5055. Again, 800-299-5055. Or visit us at www.scarrinsurance.com.
And we are back. We have another call. Pete is on the line. Hi, Pete.
Hello, how are you?
Good, buddy. How you doing?
Doing fine, thank you.
You have a question for Michael Robert?
I live in a HOA in Palm Beach County, Homeowners Association, which does not have a gated entrance. We have a problem with vehicles that are not registered riding on our streets. Not only is it a problem because they're not registered to drive on the road, but also the fact that the parents are not really policing their children. And I think that the youngest one I've seen driving one is 6 years old on their own.
How old?
At all hours,
6.
which creates a very, very
ATV?
dangerous situation.
I missed the A.
There's nothing in the bylaw that says that it's allowed. What can we do?
Well, are your streets public or private, do you know?
Hello?
Hello, can you hear me?
Now I can hear you. I'm sorry.
Are your streets public or private? Do you know?
Well, they are private roads, but we are accessed from the public road, and we've been informed that since there's an access from the public road, the extension to a public road, therefore, it's really not a clear-cut issue that anything goes.
Has the police been notified?
Police should be able to find people if they find them with a vehicle that is not properly registered and properly equipped.
Well, that's one option, but the police have to actually see it being operated in order to take any action if they're willing to come into the community. So those are a couple of hurdles that you have to cross. The other alternative for the association to deal with it would have to be a violation of your documents in some form. So there would need to be something either in the covenants or possibly in the rules of the association that can be used as a basis to say that they're in violation so that legal action can be taken. And then there has to be sufficient witnesses and documentation of the violation to present in court.
Okay. And if the current board is unwilling to go through that route, the lawlessness continues.
Well, there is the possibility that an individual homeowner can bring the legal action against another homeowner, but that would require that homeowner to use their own money to finance it, and it might not be something that any individual homeowner may want to do. So if the board is unwilling to deal with what you consider a dangerous situation, then your option becomes one of changing the board to those who are like-minded with you, either at your election or through the recall process, if there's enough owners that are in agreement with you.
Yeah. I have personally, I had some medical issues, and I recuperated at home, and I had to do some rehab at home. So obviously, I was able to witness a lot of activity in the neighborhood on a prolonged period of time, and I personally witnessed so many dangerous situations, mostly caused by juveniles, that I am amazed that nothing bad has happened yet.
Okay.
Thanks, Kate.
You should video what you can to assist in making sure that there's documentation of the violation.
Thanks, Jay.
Okay.
Let's go to
Thank
Patricia.
you.
Real quick. Hi, Patricia.
Hi. I have a quick question. Can a majority of the board members remove a director with or without cause, without actually going through the unit owners?
Hi, Patricia. Board members do not have the authority on their own to remove another director from the board without going to the unit owners. Officers can be removed and reorganized by the directors, but the director seats themselves. They are elected and appointed. They are elected by the membership, and they can only be removed by the membership. And even a board member who's been appointed by the other board members to fill a vacancy can then only be removed by the membership through a recall or at another annual election. Okay?
Thank you.
Thanks so
very
much.
Thank you.
Wow, it got kind of crazy there.
Yeah.
That's good.
Happy crazy.
Yeah. So give everybody your phone number and your website.
800-974-0680, Kaye Bender Rembaum, Community Association Lawyers, kbrlegal.com. Please check out our website. Please call us if you are looking for good legal counsel, and definitely come to our programs. They are free. We love giving the education. So
We'll be
thanks
back on
again.
Pearl Harbor Day, so get us your questions.
First Monday of the month, we have Kaye Rembaum. I keep saying Bender. Kaye Bender Rembaum. Of all people, my buddy over here.
Yeah.
Anyhow, first Monday of the month, you guys are on from 4 to 5. Tell your friends about it. Tell management about it. This is a great, great show and with a lot of great information. And we will see you next Monday between 4 and 5. This is Ask the Experts. Just Steve O today. Everybody have a great week. Peace and love. We're out.
Thanks for tuning in today to the Ask the Experts show with Steve-O and Rene. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers.